Hey, Alter Ego Warriors, how do you get a criminal case dismissed? Right? That's the $1,000,000 question. If you're charged with a crime, if you know someone is charged with a crime, you want to get that case dismissed. Well, in this video, I'm going to cover the most common ways to get your case dismissed and one of the most risky ways to try to get your case dismissed. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. Getting a criminal case dismissed. We get dozens and dozens and dozens, probably hundreds of cases dismissed. And the way that attorneys can get a criminal case dismissed varies. I'm going to talk about Washington State, though this might apply all throughout the United States. Contact your local attorney to find out. But the most common way that people think about getting a case dismissed is through a trial, right? Go to a trial and a jury or a judge finds someone not guilty. And I typically do not advise trying to get your case dismissed through a trial because that's the longest way to do it, the most expensive way to do it, and the riskiest way to do it. Let me tell you, juries don't acquit a lot of people of crimes because of the way the system is set up. I won't get into it too deeply, but think about it. You got people who are brought into court with the finger pointed at someone. You got all this system that's sort of set up to make someone appear guilty. And I think the jury often feels bad if they don't convict because that's sort of their job on their mind. So typically speaking, you don't want to take a case to trial if you can avoid it as your way to get it dismissed. I always say good attorneys go to trial, great ones don't have to, right? So if you do go to a trial, the jury has to find somebody guilty beyond a reasonable doubt. Otherwise, it could be a hung jury, or if they all agree the state or city has not proven their case, that you'll be found not guilty. Why it's risky is you get a worse penalty typically if you lose a jury trial because now there's no plea bargaining involved. You might have had to pay for a trial. It's taken years to get to a trial. It's way more stressful. Why get it dismissed through a trial if you can get it dismissed another way? So how else might we get a case dismissed? Well, one would be on motion of the prosecutor. Oftentimes, if a prosecutor is a good prosecutor, they might look at the evidence that your defense attorney presents to the prosecutor, right? Or a combination of evidence and your lack of history and things like that. And the prosecutor, on their own motion, can end up dismissing your case, right? That's the ideal situation where the government drops the case against you. We don't care why. Let's just give them to drop it. And so maybe on a city case, you can do an anger management class on a domestic violence matter, and they might agree to dismiss it. Or a theft case, maybe they have a situation where if you do a consumer awareness class and pay back the victim, that they might dismiss the case. So there's just outright the motion of the prosecutor. Another way we can get cases dismissed, and probably this is the most common in Washington State, is some type of diversionary agreement. That's a term I'm making up, but it could be used different terms in different jurisdictions. Most jurisdictions, if they have some type of diversionary agreement, it might be called a stipulated order of continuance, an SOC. What is an SOC? It's a contract between you and the government. You, as represented by yourself or yourself and your attorney, and the government through the prosecutor, where you agree to give up certain rights, like your right to a trial, your right to a jury trial, your right to a speedy trial, your right to contest evidence. And the government agrees to give you a certain reward, oftentimes a dismissal, if you live up to the terms of the agreement. So that's awesome if we can get that, right? We control the outcome. What's typically in the agreement? Obviously, no new criminal law behavior, and sometimes some affirmative things. Like in some places, if you get charged with domestic violence, they might want you to do a 6-month DV MRT class. If you get charged with a theft, maybe they have you do community service and a theft awareness class, and you pay back whoever got their property taken from them, that type of thing. So an SOC is a great tool for a dismissal because it's not a plea of guilt, right? If you violate the SOC, it'll result in a guilty finding in most cases, but it is not a plea of guilt, and you'll be able to earn a dismissal. Now, how long does this contract last for? It varies. Could be 18 months, it's pretty common. Could be 24 months. 6 months, 12 months, it depends, and your attorney may be able to negotiate for that. And so, and sometimes if you think you're going to reoffend, you might not want to take an SOC if you get the option, but oftentimes it's a beautiful vehicle to try to get a case dismissed, again, without having to go to the trial. Your attorney shows the weaknesses to the prosecutor, shows your good record to the prosecutor, shows the classes that you're doing to the prosecutor, so you're a better risk to earn an SOC, and that will let us control the outcome with our own behavior. And we want to control the outcome. We don't want to leave it up to the jury, do we, to decide if we're guilty or not. Let's get the dismissal on our own. So I call that like a discretionary diversion program with a prosecutor. They're called different things. Dispositional continuance in Seattle. Some places might call it a friendship diversion. There's community court. There's all types of stuff like that. How else can we get a case dismissed? Well, if you got a felony matter, some counties have felony diversionary programs, I'm going to call it. Snohomish County has TAP, therapeutic alternatives to prosecution. If a crime is caused by drugs or a crime is caused by mental health issues, you might be able to do it that way. There's also drug court. Most places have a drug court where if it's a drug-related offense, you can go through a period of drug treatment with support from drug counselors, things like that. And at the end of drug court, if you make it through, oftentimes that ends in a dismissal, right? So if you're charged with a felony, don't give up. If it's not a very serious felony, you may be able to look at getting that case dismissed through some type of felony diversionary program, which is pretty good. Okay, what about other statutory ways to get a case dismissed? Well, there's something called deferred prosecution. Deferred prosecution exists in Washington State, where if our non-felony matter is caused by alcoholism, drug addiction, or mental health problems, we may be able to do a treatment program that results in the dismissal of our case. It's not even discretionary. The prosecutor doesn't have to agree to it, right? The judge has to put us in the program, but we get an evaluation that recommends us for the program. Your attorney will know how to do that. It's most commonly used for DUIs. You can do one deferred prosecution a lifetime for DUI to get your DUI case dismissed. If it's an alcohol-based deferred prosecution, you'll need 2 years of alcohol treatment and 5 years to stay out of the trouble. But again, you control the outcome. The dismissal comes from your actions, and that one the prosecutor does not have to agree to. Another way to get a case dismissed is compromise of a misdemeanor. If you have a misdemeanor where the victim of the crime has a civil cause of action for money, then the statute says if the victim appears in court and signs off that they've been satisfied, you could ask the court to dismiss the case. Hit and run cases that may work for if it's not a felony, standard hit and run attended or not attended. Theft 3 cases, sometimes you can do that on an assault case, malicious mischief cases, criminal trespass cases. All those type of things, the victim may have a civil cause of action, and if we pay them for their damages or they say they have no damages and sign off, then your attorney can bring an action under RCW 10.22.010 to dismiss the case. And again, the prosecutor does not have to agree. Sometimes they'll object, but the statute does not require their assent, their agreement, for you to get that dismissal, right? That's another great way we can get many charges dismissed without ever having to go to the trial. So the primary method, though, again, is some type of agreement from the prosecutor. And what is the method to that madness? We always say there's 3 things. 1 is you don't want to negotiate the case very early. You want some time to pass. 2, generally, you need to do some stuff. Client or defendant, you need to do some stuff. Do some educational classes. Better yourself. If it's related to domestic violence, let's do some best domestic violence classes. If it's related to DUI, let's do some alcohol and drug evaluations. If it's related to some type of depression you're suffering, let's get into some counseling. Let's try to help better ourselves. Let's make the most out of the crisis, right? Then we can use that on those evidentiary problems that your attorney develops or your attorney sees from experience. And hopefully you're likely to need criminal history, sometimes the wishes of the victim. All those things can combine to the parties working out some type of situation where your case eventually ends in a dismissal without you having to get to that trial. I want you to think about it that way. Think about the ways out of the case without leaving it up to the 6 people or 12 people who aren't smart enough to get out of jury duty, right? Do we want them deciding whether or not we go home if we can avoid it? No, we don't. I'll answer it for you. No, you don't. So those are the ways, many of the ways to get a case dismissed if you're charged with a crime. It's not impossible. It can be done. And hopefully that's where you will end up as well. So if you found this useful, please like and please subscribe. More people get the help they need. More importantly, if you've got a legal problem in Washington State, you can give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.